For any of you aspiring lawyers out there, this is where the rubber really hits the road. You see, contract drafting isn't just about putting legal words on a page. It's about building a fortress for your client. One wrong word, one little misplaced comma can literally cost millions. So in this explainer, we're going to give you the tools to move from that dangerous ambiguity to absolute ironclad precision.
So let me ask you this. Just think about it for a second. Could a single word, maybe even just a comma, completely unravel a multi-million-dollar deal? The answer, and this should send a little shiver down the spine of any lawyer, is a huge, resounding yes. Precision in your contracts isn't just about being a good writer. It's about being your client's first, and maybe last, line of defense.
And this right here, this is the enemy, contract ambiguity. It's like this legal fog that rolls in when your language is just too loose. It creates loopholes and becomes a breeding ground for incredibly expensive, time-sucking litigation. Our entire mission today is to cut right through that fog and leave zero room for doubt. So here's our game plan. We're going to start by really understanding the high cost of ambiguity. Then we'll dive deep into the foundations of smart drafting, from how you structure it to the very words you choose. And we'll wrap up by looking at common traps you got to avoid and a final checklist to make sure your work is absolutely airtight. Let's get into it. First up, let's talk about why precision is so much more than just a style choice. It is, without a doubt, your single best defense against any future conflict. This quote from our source material, this is the golden rule. Seriously. Unlike a novel where a little ambiguity can be a beautiful thing, in a contract, it's a massive liability. Your job is to be an architect of certainty. Every single sentence, every word, has to be engineered to lead to one and only one possible interpretation, the one that protects your client. So how do we actually do that? Well, it all starts way before you even write the first clause. Let's dig into the foundations of smart drafting. Okay, rule number 1, never start with a blank page. First, you build your blueprint. That's the term sheet. This is where you lay out the absolute core of the deal and your client's non-negotiables. Next, why reinvent the wheel, right? Find strong precedents, previous agreements that give you a battle-tested foundation. Only then do you start to adapt and draft. This process isn't just about being efficient, it's about building on what already works and avoiding those common pitfalls from the get-go. Just look at the difference here. Any part thereof, that's classic, clunky legalese. Any of its parts, that's plain English. They mean the exact same thing. But the second one is instantly clearer to everyone, especially the judge, who might have to read it one day. Remember, being clear isn't dumbing it down. It's being smart. It's strategic. And this whole idea of clarity, it goes way beyond just the words you pick. It's about the entire framework of the contract. How you structure your agreement is every bit as important as the words you use inside it. These rules are super simple, but honestly, they're game changers. Keep your sentences short. If it's pushing past 3 lines, it's probably too long. Break up those dense, long provisions into smaller, more digestible chunks. And please, use descriptive headings. Think of it like you're creating a clear, easy-to-follow map of the agreement for anyone who picks it up. Okay, now we're getting to what might be the most critical part, the specific words you choose. In contract law, certain words aren't just words. They're like surgical instruments that carry a ton of weight and very specific meaning. Listen up. You need to burn these 3 words into your brain. Shall is a command. It creates a mandatory duty, something must be done. Will simply states a future fact. And may creates an option. A party has the right to do something, but not the obligation. If you get these wrong, you could accidentally turn a mandatory payment into an optional one. Yeah, the stakes are that high. So now that we have the building blocks down, let's talk about the common mistakes, the traps that can trip up even some really experienced drafters. These are the unforced errors we want to completely eliminate from our game. See the structure here. The first example kind of forces the reader to pause and mentally reassemble the sentence to figure out what's going on. But the correct version? It's immediate. It's clear. Exelon may not transfer. By keeping the core of your sentence together, the subject, the verb, the object, you just make it easier to understand and you kill any chance of misinterpretation. It's all about making your point as directly and powerfully as you can. Oh, this is such a classic trap, burying your verbs inside these abstract nouns. Issuance of the stock. It's passive, it's a little vague. Who's doing the issuing? The correct version, Exelon issues the stock, is active and precise. It clearly assigns responsibility. Always ask yourself, Who is doing what? If your sentence doesn't answer that, rewrite it until it does.
Okay, pay close attention, because this right here is where millions of dollars can be won or lost, often during negotiation. Qualifiers like material are not just filler words. They set the bar for what actually counts as a breach of contract. A promise not to violate any law, that's an impossibly high standard to meet. But a promise not to violate any material law, totally different story. And violating a law in any material respect is an even lower bar. As the drafter, your choice of words here directly impacts your client's level of risk.
And finally, before any contract goes out the door, it's time for the final review. Think of this as your absolute last line of defense against any embarrassing errors or lingering ambiguity. You have to run through this checklist every single time, no exceptions. Are your terms consistent? Don't switch from calling something goods on page 1 to items on page 10. Are all your defined terms capitalized like they should be? Are your cross-references actually pointing to the right sections? And have you scrubbed any old-fashioned gender-specific language? These details really, really matter. Because when you get right down to it, this is the goal. Your job is to take a complex, sometimes messy business deal and transform it into a document that is crystal clear, that tells people exactly what they need to do, and that will absolutely stand up in court if it's ever challenged. That, right there, is the mark of a great transactional lawyer. So, I'll leave you with a question to chew on. Whether it was in a textbook case or maybe something you saw in the real world, what's the most dangerously ambiguous phrase you've ever come across? Thinking about the mistakes other people have made is one of the best ways to sharpen your own skills.